The temperature in my home office dropped to 48 degrees before I realized something was seriously wrong with my heating system. And by then, my space heater had vanished from my garage. My name is Cole Irving, and I have lived in the Meadowbrook Heights subdivision in suburban Denver, Colorado, for 3 years. I bought my modest 2-story home in 2022, thinking I had found a perfect place to settle down after my divorce. The neighborhood seemed quiet, the houses well-maintained, and the mountain views from my back deck made the premium HOA fees seem almost justified. Almost. The problem started in mid-January, right when Colorado decided to remind everyone why proper heating matters. My furnace began making concerning grinding noises, and my HVAC technician informed me that a critical part would take 2 weeks to arrive. He apologized profusely, explaining that supply chain issues were still affecting certain components. I was not thrilled, but I had prepared for this exact scenario. 6 months earlier, I purchased a high-quality industrial space heater for my garage workshop. The unit cost me nearly $400, but it was worth every penny. The heater was powerful enough to keep my detached garage comfortable while I worked on my vintage motorcycle restoration project. I moved the heater into my house, setting it up in my home office where I spent most of my workday. As a software developer, I needed my fingers warm enough to type. The space heater performed beautifully, keeping my office at a comfortable 68 degrees while I waited for the furnace part. On the morning of January 23rd, I walked out to my garage to grab some tools. My garage door was closed but unlocked, which struck me as odd. I always locked it. Inside, I immediately noticed the empty space where my motorcycle usually sat. My heart rate spiked before I remembered that I had taken the bike to my friend's shop for some welding work. But something else was wrong. The space heater I had moved back to the garage the previous evening was gone. I searched everywhere. Behind my workbench, in the storage closets, even in my car trunk, thinking maybe I had experienced some kind of blackout and moved it myself. Nothing. The heater had disappeared. That afternoon, I received an email from Brenda Carmichael, the president of the Meadowbrook Heights Homeowners Association. Brenda was 52 years old, had short blonde hair cut in what people call a speak-to-the-manager style, and wore reading glasses on a chain around her neck. She drove a white Lexus SUV with a license plate frame that read, "Proud HOA President," which should have been my first warning when I moved in. The email subject line read, "Violation Notice Unpermitted Equipment Storage." I opened it with growing dread. Dear Mr. Irving, during a routine compliance inspection of our community, it was observed that you have been storing commercial-grade heating equipment in your attached garage in violation of Meadowbrook Heights HOA Covenant Section 7.3, which prohibits the storage of industrial equipment in visible or semi-visible areas. The equipment in question has been confiscated and will be returned upon payment of a $250 fine and written assurance that the violation will not reoccur. Please contact the HOA office to arrange payment and retrieval. Regards, Brenda Carmichael, HOA President. I read the email 3 times, my anger building with each pass. Several things were wrong with this scenario. First, my garage was detached, not attached. Second, I had never heard of Section 7.3. Third, and most importantly, she had entered my property and taken my personal belongings without permission. I pulled out my HOA covenant documents, all 78 pages of them. I spent 2 hours reading through every section, paying special attention to anything numbered 7.3 or relating to garage storage. There was no such provision. Section 7.3 actually dealt with fence height restrictions. There was absolutely nothing about space heaters, industrial equipment, or garage storage limitations beyond standard municipal codes about hazardous materials. I drafted a careful email response. Brenda, I received your notice regarding my space heater. After reviewing the complete HOA covenant documents, I cannot locate any Section 7.3 that relates to equipment storage. The actual Section 7.3 addresses fence heights. Additionally, my garage is detached, not attached, and is not visible from the street or common areas. More importantly, you entered my private property without permission and removed my personal property without my consent. This constitutes theft. I expect my space heater returned immediately, or I will be forced to file a police report. Cole Irving. Her response arrived within 15 minutes. Mr. Irving, I suggest you review the updated covenant amendments passed in November of last year. All homeowners were notified via email and approved the changes by majority vote. As HOA president, I have the authority to enter any property within our community to ensure compliance with our standards. Your space heater will be returned when you pay the fine and comply with HOA regulations. This is non-negotiable. Brenda. I checked my email archives. There was no notification about covenant amendments in November. I received the monthly HOA newsletter, various violation notices for trivial matters like leaving my trash cans visible for 3 hours past collection time, but nothing about voting on amendments. I called my neighbor, Robert Patterson, a retired accountant who had lived in Meadowbrook Heights for 12 years. Robert answered on the second ring. Rob, did you receive anything about voting on HOA covenant amendments last November? Covenant amendments. No, nothing. Why? Brenda claims there was a vote about new storage restrictions. Robert laughed, but it was not a happy sound. Cole, Brenda has been trying to expand her authority for years. Last year, she tried to ban pickup trucks from being parked in driveways. The year before that, she wanted to require pre-approval for any exterior paint colors, even if you were painting your house the exact same color it already was. Most of her proposals get shot down, so sometimes she just pretends they passed. She can do that. She tries. Most people do not read the emails carefully or check the actual covenant documents. They just pay the fines because it is easier than fighting. It is extortion, basically, but she hides behind the HOA authority. This information made my blood boil, but I forced myself to stay calm. She took my space heater from my garage. From your garage? How did she get in? That is what I am wondering. Call the police, Cole. That is theft. I do not care what kind of HOA authority she claims to have. I thanked Robert and hung up. Before calling the police, I decided to try one more direct approach. I drove to Brenda's house, which was the largest home in the subdivision, a sprawling ranch-style property with an immaculate lawn and more decorative shutters than any building reasonably needed. I rang the doorbell. Brenda answered wearing a pink velour tracksuit and holding a small white dog that yapped aggressively at me. Mr. Irving, I told you to handle this matter via email. I want my space heater back, Brenda, and I told you the terms for its return. There was no vote in November. There is no covenant provision about space heaters. You stole my property. Her face reddened. I did not steal anything. I confiscated equipment that violated community standards. Show me the provision. It is in the updated documents, which I never received and which do not exist. The small dog's yapping intensified. Brenda's voice rose to match it. Mr. Irving, I have been president of this HOA for 6 years. I know the rules better than anyone. If you continue to harass me at my home, I will file a restraining order. If you do not return my property, I will file a police report. Go ahead. The police will tell you this is a civil matter between you and the HOA. Now leave my property before I call them myself." She slammed the door. I stood on her porch for a moment, breathing deeply, trying to control my temper. Then I walked back to my truck and drove directly to the Adams County Police Department. The officer at the front desk was a young woman named Deputy Sanchez. I explained the situation as calmly as possible. She listened, took notes, and asked several clarifying questions. "So the HOA president entered your garage and took your space heater?" "Yes." "Do you have proof she took it?" "She sent me an email saying she confiscated it." "Can I see that email?" I pulled it up on my phone. Deputy Sanchez read it carefully, then excused herself to speak with a supervisor. She returned 5 minutes later with an older officer, Sergeant Morrison. "Mr. Irving, I am Sergeant Morrison. Deputy Sanchez briefed me on your situation. This is a bit unusual. Normally, HOA disputes are civil matters, but the fact that she admitted in writing to taking your property changes things. We can file a theft report, but I want to be clear about expectations. The district attorney will decide whether to press charges, and that decision often depends on the value of the property and the circumstances. The heater cost $400. That is above the threshold for petty theft in Colorado. It would be fourth-degree theft, a misdemeanor. Here is what I recommend. We will go with you to speak with Miss Carmichael. Often, when people realize the police are involved, they become more cooperative. If she returns the property, you can decide whether you still want to press charges." I agreed. Sergeant Morrison and Deputy Sanchez followed me back to Brenda's house in their patrol car. The sight of police vehicles in Meadowbrook Heights caused immediate curtain twitching in several windows. This neighborhood loved gossip. Sergeant Morrison knocked on Brenda's door. She opened it, saw the uniforms, and her confident demeanor evaporated. "Officers, what is this about?" "Madam, I am Sergeant Morrison. We are here regarding a theft report filed by Mr. Irving concerning a space heater. He claims you removed it from his property without permission." "This is an HOA matter. I have authority to enforce covenant regulations." "Madam, HOA authority does not extend to entering private property and removing personal belongings without consent. That is theft, regardless of your position. The covenants give me the right to inspect properties." "Inspection is not the same as confiscation. Where is the space heater now?" Brenda hesitated. Her small dog appeared at her feet, growling at everyone. "It is in my garage, but I am not giving it back until he pays the fine." "That is not how this works," Sergeant Morrison said patiently. "You have two options. You can return Mr. Irving's property right now, or we can arrest you for theft and retrieve the property through evidence collection. Your choice. Arrest me for enforcing community standards, for taking something that does not belong to you without permission. That is theft." I watched Brenda's face cycle through several emotions: shock, anger, calculation, and finally resignation. "Fine, wait here." She disappeared into her house. We stood on the porch in awkward silence. 2 minutes later, Brenda returned, struggling with my space heater. It was heavy, about 30 pounds. Deputy Sanchez stepped forward to help, but Brenda yanked it away and shoved it at me with unnecessary force. "Here, I hope you are happy." "I want to know how you got into my garage," I said. "Your garage was unlocked." "It was locked. I always lock it." "Then you forgot. I did not break in." Sergeant Morrison intervened. "Mr. Irving, do you want to press charges?" I looked at Brenda, who stared back with undisguised hostility. Part of me wanted to let it go, but I thought about what Robert had said. She had been doing this to people for years. Yes, I want to press charges. Brenda's mouth fell open. You cannot be serious. You stole my property. You admitted it in writing. You only returned it when police forced you to. Sergeant Morrison nodded. Miss Carmichael, we need you to come to the station to complete a formal statement. I did not steal anything. That will be determined by the district attorney. You can come voluntarily now or we can arrest you. Again, your choice. Brenda chose to come voluntarily, though her cooperation was grudging. I returned home with my space heater, set it back up in my office, and felt a satisfaction that went beyond just warmth. The following days were interesting. Brenda apparently called an emergency HOA board meeting. The board consisted of herself, two other members named Patricia Wu and Donald Greaves, and a secretary named Margaret Foster. According to Robert, who attended every board meeting, Brenda tried to rally support for community defense against my harassment and abuse of the legal system. It did not go well for her. Patricia and Donald had apparently been increasingly uncomfortable with Brenda's aggressive enforcement tactics. Margaret, who kept detailed minutes of all meetings, confirmed that no vote on covenant amendments had occurred in November or any other time in the past 18 months. Brenda got defensive when we questioned her. Robert told me over coffee at my kitchen table 3 days after the police incident. She insisted she had the authority to interpret and enforce the covenants as needed to maintain community standards. Donald asked her to show us where in the documents it said she could confiscate personal property. She could not. What happened then? Patricia moved to have Brenda removed as president pending the outcome of the criminal charges. The motion passed 2-1, with Brenda voting against, obviously. Patricia is now interim president. This was encouraging news, but I knew the legal process was just beginning. The district attorney's office contacted me the following week. A prosecutor named Michael Hernandez wanted to meet to discuss the case. I met Michael at his office in Brighton, Colorado. He was in his late 30s, professionally dressed, with a no-nonsense attitude that I appreciated. Mr. Irving, I have reviewed your case. Normally, we do not prosecute HOA disputes, but this situation is unusual. Miss Carmichael admitted in writing to taking your property. She only returned it when police intervened. That establishes clear intent and consciousness of wrongdoing. So you will prosecute. I am going to offer her a plea deal first. If she pleads guilty to 4th-degree theft, we will recommend a suspended sentence, restitution for any damages, and resignation from the HOA board. If she refuses, we will go to trial. What are the chances she takes the plea? Honestly, 50-50. Some people cannot accept responsibility for their actions, especially when they think they were justified. We will see. Brenda rejected the plea deal. According to Michael, she maintained she had done nothing wrong, and that prosecuting an HOA president for enforcing community rules set a dangerous precedent. She hired an attorney, an aggressive-looking man named Richard Blackstone who specialized in property law. The weeks leading to trial were tense. I received several hostile letters from homeowners who supported Brenda, accusing me of destroying the neighborhood's stability over a minor dispute. I also received supportive messages from homeowners who thanked me for standing up to Brenda's overreach. The community was divided. Robert kept me informed about HOA developments. Patricia, the interim president, immediately suspended all outstanding fines pending a complete review of Brenda's enforcement actions over the past 2 years. They discovered dozens of questionable citations, many based on covenant provisions that either did not exist or had been significantly misrepresented. There is talk of a class action lawsuit, Robert said. About 15 homeowners paid fines totaling over $8,000 for violations that were not actually violations. Brenda might have bigger problems than your criminal case. The trial was scheduled for late March. Colorado weather was unpredictable that time of year, swinging between 60-degree sunshine and surprise snowstorms. Trial day arrived with gray skies and a cold wind that promised snow. Adams County Court was busy that morning. I arrived early with Michael Hernandez. We met in a conference room to review my testimony one last time. "Keep it simple," Michael advised. "Just tell the truth about what happened. Do not embellish. Do not get emotional. Richard Blackstone will try to make this about HOA authority and community standards. We need to keep the focus on the basic facts. She took your property without permission. That is theft." The courtroom was smaller than I expected, with maybe 60 seats in the gallery. About 20 people were there, a mix of curious neighbors and court regulars. Brenda sat at the defense table with Richard Blackstone, wearing a conservative blue dress and a martyred expression. The judge was Honorable Linda Fitzgerald, a stern-looking woman in her 60s with gray hair and sharp eyes. She had a reputation for running an efficient courtroom and suffering no foolishness from attorneys or witnesses. "All rise," the bailiff announced. We stood as Judge Fitzgerald entered. She surveyed the courtroom, sat, and gestured for everyone else to sit. Case number 2025 CR 1847, People of Colorado versus Brenda Carmichael charged with fourth-degree theft. Are both sides ready to proceed? Michael stood. "Yes, Your Honor." Richard Blackstone stood. "Yes, Your Honor." "Very well." Mr. Hernandez opening statement. Michael approached the jury box. 12 jurors watched with varying degrees of interest. "Ladies and gentlemen, this is a straightforward case. The defendant, Brenda Carmichael, entered the victim's property without permission and took a $400 space heater. She admitted doing so in writing. She only returned the property when police became involved. The law is clear. Taking someone else's property without permission is theft. The defendant's position as HOA president does not give her authority to commit crimes. Thank you. Richard Blackstone's opening was more elaborate. He painted Brenda as a dedicated community servant trying to maintain standards in an increasingly chaotic world. He argued that HOA authority included reasonable enforcement powers, and that Brenda genuinely believed she was acting within her rights. This is a case about a good woman who made a mistake in judgment, not a criminal. The prosecution wants you to treat an HOA dispute as theft. That is absurd. Miss Carmichael did not steal anything. She temporarily removed equipment she believed violated community rules, with every intention of returning it once the matter was resolved. That is not theft. That is not criminal. And we ask you to return a verdict of not guilty. Judge Fitzgerald called me as the first witness. I took the stand, swore to tell the truth, and sat down, trying to ignore my nervous heartbeat. Michael led me through the basic facts. When I purchased the space heater, where I stored it, why I moved it into the house, and then back to the garage. I described discovering it missing and finding the garage unlocked. Did you give Miss Carmichael permission to enter your garage? No. Did you give her permission to take your space heater? No. What did you do when you discovered it was missing? I received an email from Miss Carmichael saying she had confiscated it. Michael entered the email into evidence. What was your reaction to this email? I was angry. She admitted taking my property and demanded I pay a fine to get it back. Did you pay the fine? No, I contacted the police. Why? Because she stole my property. Richard Blackstone cross-examined me aggressively. He tried to establish that I frequently left my garage unlocked, suggesting Brenda had a reasonable belief she was authorized to enter. I maintained that I always locked my garage. He tried to suggest the space heater was not really worth $400. I produced the receipt. He tried to paint me as someone with a grudge against the HOA who was weaponizing the legal system. Mr. Irving, is it not true that you have received multiple violation notices from the HOA? Yes. How many? I do not know exactly. Maybe 10 or 12 over 3 years. Were these violations legitimate? Some were, some were not. You sound bitter about the HOA's enforcement. I am frustrated when I am cited for violations that do not exist in the actual covenant documents. So you admit you have an antagonistic relationship with the HOA. I have an antagonistic relationship with people who make up rules and then steal my property. Judge Fitzgerald intervened. Mr. Blackstone, is there a question? Your Honor, I am establishing the witness's bias and potential motive to falsely accuse my client. He already testified that she took his property and admitted it in writing. Move on. The prosecution called Deputy Sanchez next. She described responding to my complaint and accompanying Sergeant Morrison to Brenda's house. Her testimony was professional and matter of fact. What did Miss Carmichael say when you asked about the space heater? She confirmed she had taken it from Mr. Irving's garage and was keeping it in her garage. Did she claim she had permission? No. She said she had authority as HOA president to enforce compliance. What happened next? Sergeant Morrison explained that HOA authority does not permit entering private property and taking personal belongings. He gave her the option to return the property or be arrested. What did she choose? She returned the property, but she was very reluctant and argumentative about it. Richard Blackstone tried to shake Deputy Sanchez's testimony, but made little progress. She stuck to the facts and did not speculate about motivations or intentions. The prosecution rested. Richard Blackstone called Brenda to testify in her own defense. She took the stand with visible confidence, clearly believing she could convince the jury of her good intentions. Miss Carmichael, how long have you been HOA president? 6 years. During that time, have you been dedicated to maintaining and improving the community? Absolutely. I have worked tirelessly to keep property values high and ensure our neighborhood remains beautiful and safe. Tell the jury about your inspection of Mr. Irving's property. I was conducting a routine compliance check in January. I noticed Mr. Irving's garage door was open. I could see large industrial equipment inside, which violates our community standards. What did you do? I entered the garage to get a closer look at the equipment. It was a very large commercial heater, completely inappropriate for residential use. It posed a potential fire hazard. This was a lie. My space heater was not commercial grade in the industrial sense, and my garage door had been closed, not open, but I had to sit quietly and let the process continue. Why did you remove the heater? For safety reasons. I planned to return it once Mr. Irving agreed to keep it in compliance with regulations. Did you intend to steal it? Of course not. I intended to temporarily hold it pending resolution of the violation. When the police arrived, did you immediately cooperate? Yes. I gave Mr. Irving his property back right away. This whole situation has been blown completely out of proportion. Michael's cross-examination was surgical. Miss Carmichael, you testified that Mr. Irving's garage door was open when you conducted your inspection. Yes. Mr. Irving testified it was closed and locked, which is true. I am telling the truth. He must be mistaken. Is it possible you are mistaken? No. You also testified that the space heater was commercial-grade industrial equipment. Yes, it was very large. Have you seen the space heater in question? Of course. I removed it. Michael produced my space heater, which had been entered into evidence. He placed it on a table in front of the jury. It was about 15 inches tall, painted black, with a standard household plug. "Does this look like commercial-grade industrial equipment to you?" Brenda hesitated. "It is still larger than a typical home heater. It weighs 30 pounds and plugs into a standard wall outlet. Does that sound industrial? It could be a safety hazard." That was not my question. "Is this commercial-grade industrial equipment?" I believed it was at the time. "Based on what expertise? Are you a fire safety inspector?" "No, but I have common sense. Common sense that told you to enter someone's private property, take their belongings, and demand money for its return." "Objection," Richard said. "Argumentative." "Sustained," Judge Fitzgerald said. "Rephrase, Mr. Hernandez. Miss Carmichael, did you have Mr. Irving's permission to enter his garage?" "I do not need permission. The HOA covenants grant inspection authority." "Show me where." "I do not have the documents with me." "I do." Michael produced a copy of the HOA covenants. "Please point to the section that grants you authority to enter private garages without permission." Brenda flipped through pages, stalling. "It is in here somewhere. Take your time." Minutes passed. The courtroom was silent except for rustling paper. Finally, Brenda said, "I cannot find the specific section right now, but I know it exists." "It does not exist, does it?" "It might be in the amendments." "What amendments?" The board secretary testified that no amendments have been passed in 18 months. "There were email votes. Show me documentation of these email votes." "I do not have it with me." "You do not have it because it does not exist. You made it up, did you not?" "I did not make anything up." Her voice rose, echoing in the courtroom. Judge Fitzgerald leaned forward. "Miss Carmichael, please control your volume." Michael continued calmly. "You sent Mr. Irving an email demanding $250 for the return of his property, correct?" "I was levying a fine for the violation." "A violation that does not exist in the actual covenant documents." "The violation exists, based on rules you invented, based on my understanding of community standards. And when Mr. Irving refused to pay, you refused to return his property." "I was following proper procedures." "What procedures?" "Show me the HOA procedure for confiscating property and demanding ransom." "It is not ransom, it is a fine." "You took his property. You demanded money. You refused to return it until money was paid. In what universe is that not theft?" "Objection." Richard stood quickly. "Calls for a legal conclusion." "Withdrawn," Michael said. "No further questions." The prosecution called several more witnesses. Margaret Foster, the HOA secretary, testified about the absence of any amendments or provisions authorizing property confiscation. Patricia Wu, the interim president, testified about discovering numerous questionable enforcement actions during their review of Brenda's records. Robert Patterson testified about community concerns regarding Brenda's overreach. The defense called character witnesses who praised Brenda's dedication and hard work. A neighbor testified that the HOA ran more efficiently under Brenda than previous presidents. Another neighbor testified that property values had increased during Brenda's tenure. None of it changed the basic facts. Brenda had taken my property without permission. Closing arguments were scheduled for the following morning due to time constraints. I went home exhausted, heated some soup, and fell asleep on my couch with the space heater running beside me, a small irony that was not lost on me. The next morning was Friday. Judge Fitzgerald's courtroom was more crowded than the previous day. Word had spread about the case, and curious onlookers filled most of the gallery seats. Michael's closing argument was concise. "Ladies and gentlemen, this case is simple. The defendant took property that did not belong to her without permission. She admitted it. She only returned it when police forced her to. That is theft. Her position as HOA president does not give her special rights to commit crimes. Her belief that she was enforcing community rules does not justify stealing. The law applies equally to everyone, including HOA presidents. We ask you to return a guilty verdict. Richard Blackstone's closing was emotional. He portrayed Brenda as a victim of an overzealous prosecution, a dedicated volunteer being punished for trying to maintain community standards. He argued that criminal intent was lacking, that Brenda genuinely believed she was acting within her authority, and that criminalizing HOA enforcement would create chaos in communities across Colorado. This is not theft, Richard insisted. This is a civil dispute being prosecuted as a crime. Miss Carmichael is not a criminal. She is a homeowner who volunteered her time to serve her community. She made a mistake in judgment, perhaps, but mistakes are not crimes. We ask you to see through the prosecution's overreach and return a verdict of not guilty. Judge Fitzgerald instructed the jury on the law. She explained the elements of theft, the requirement for criminal intent, and the burden of proof. The jury retired to deliberate at 11:30 in the morning. Jury deliberations are unpredictable. Sometimes they take days. Sometimes they take hours. This jury deliberated through lunch. At 2:45, the bailiff announced they had reached a verdict. Everyone filed back into the courtroom. The jury foreman, a middle-aged man in a business suit, stood when Judge Fitzgerald asked if they had reached a verdict. "We have, Your Honor." "What is your verdict?" "We find the defendant guilty of fourth-degree theft." Brenda gasped. Her face went pale. Richard put a hand on her shoulder, but she shook it off. Several people in the gallery murmured. Judge Fitzgerald gavelled for silence. "Order." The jury is dismissed with the court's thanks. Miss Carmichael, sentencing is scheduled for 3 weeks from today. You will remain free on your own recognizance until then. This court is adjourned. The gavel struck. People began filing out. I felt relief wash over me, not triumph exactly, but vindication. The legal system had worked. Michael shook my hand. Good outcome. I will be recommending minimal sentencing given this is a first offense, but the conviction itself sends an important message. Brenda and Richard left quickly, avoiding eye contact with everyone. I saw Brenda crying in the hallway, surrounded by a few supporters. Part of me felt sorry for her, but mostly I felt relieved it was over. 3 weeks later, I returned for sentencing. Judge Fitzgerald reviewed the case, acknowledged Brenda's lack of criminal history, but also noted the severity of abusing a position of trust. Miss Carmichael, you were elected to serve your community, not to exploit that position for personal authority. You took someone's property without permission, admitted it, and only returned it when forced to by police. That is unacceptable. However, I also recognize this is your first offense. I am sentencing you to 1 year of supervised probation, 100 hours of community service, and restitution to Mr. Irving for any costs associated with this matter. You are also prohibited from serving in any HOA leadership position for 5 years. You understand? Brenda nodded, tears streaming down her face. Yes, Your Honor. Mr. Irving, do you wish to make a statement? I stood. Your Honor, I did not pursue this case out of spite. I pursued it because people in positions of authority need to be held accountable. Miss Carmichael abused her position for years, imposing fake fines and making up rules. This needed to stop. I hope this case sends a message to HOA leaders everywhere that they are not above the law. Thank you. Judge Fitzgerald nodded. Well said. This case is concluded. The aftermath was interesting. The class action lawsuit Robert had mentioned moved forward. 15 homeowners sued the HOA for return of improperly collected fines. The HOA settled for $12,000. paid from the reserve fund, which meant all homeowners effectively bore the cost through special assessment. But Brenda was personally sued by 3 homeowners for intentional misrepresentation. Those cases were still pending when I last checked. Patricia Wu served the remainder of Brenda's term as president and ran for election in her own right. She won easily. Under Patricia's leadership, the board implemented new transparency measures. All enforcement actions now required documentation, citing specific covenant provisions, with copies provided to homeowners. A new appeals process allowed homeowners to challenge citations before an independent arbitrator. The monthly newsletter published detailed financial reports and board meeting minutes. The changes transformed the community. Enforcement became fair and reasonable. People stopped living in fear of arbitrary citations. Property values remained stable, proving that reasonable governance worked just as well as authoritarian control. Brenda moved out of Meadowbrook Heights 6 months after her conviction. She sold her house and relocated somewhere in Wyoming, according to neighborhood gossip. I did not keep track of her. My focus was on moving forward. My furnace was finally repaired, but I kept the space heater. It sat in my garage, a reminder of the entire ordeal. Occasionally, I would look at it and shake my head at the absurdity of everything that had happened over a simple heating device. The following winter, when temperatures dropped and my furnace struggled during a particularly brutal cold snap, I brought the space heater back inside. It kept my office warm while I worked, a faithful device that had inadvertently changed an entire community. Robert and I remained friends. We occasionally met for coffee and discussed HOA matters, though the conversations were far less dramatic than before. Patricia ran a competent, fair board. Violations were real and appropriately addressed. Fines were reasonable and properly documented. The HOA functioned the way it was supposed to. One afternoon in late March, almost a year after the trial, I received a letter in the mail. The return address was from Wyoming. I opened it carefully. The letter was from Brenda. "Mr. Irving, I doubt you want to hear from me, and I understand if you throw this letter away without reading it. But I have been working with a therapist for the past year, trying to understand why I behaved the way I did. I realize now that I let the power of the position go to my head. I convinced myself that strict enforcement was necessary for the community's good, but really, I was on a power trip. I made life miserable for a lot of people, including you. I am genuinely sorry for taking your space heater and for all the trouble I caused. You were right to hold me accountable. I needed to learn that lesson, though I wish I had learned it differently. I hope you are doing well and that the community is thriving. Sincerely, Brenda Carmichael." I read the letter twice. It seemed sincere. Whether Brenda had truly changed or was just going through the motions of rehabilitation, I could not know. But the letter showed at least some awareness of her mistakes, which was more than I expected. I wrote a brief response. "Brenda, thank you for your letter. I appreciate the apology. What happened was unfortunate for everyone involved, but hopefully some good came from it. The HOA is running smoothly under new leadership, and the community is better for the changes that were made. I wish you well in your new home. Cole Irving." I mailed the letter and felt a sense of closure. The whole ordeal had been exhausting and frustrating, but it reinforced an important principle. Nobody is above the law, regardless of their position or their claimed authority. HOA presidents, managers, board members, they all operate within defined limits, and when they exceed those limits, they need to be held accountable. My story spread through HOA communities across Colorado and beyond. I received emails from homeowners dealing with similar issues, asking for advice. I always gave the same response. Document everything, know your rights, read your actual covenant documents, and do not be afraid to involve authorities when laws are broken. Several local news stations covered the case. I did one television interview, keeping it brief and focused on the principle rather than personal grievances. The reporter asked me what advice I would give to other homeowners. Read your HOA documents. Seriously, read them. All of them. Know what rules actually exist versus what people claim exists. And if someone in authority abuses their position, stand up to them. It is not easy and it takes time and energy, but it is worth it. Communities function better when everyone operates within the law, including the people in charge. The interview aired during the evening news. My phone rang for days afterward with calls from reporters, homeowners, and even a few attorneys asking me to speak at seminars about HOA governance. I declined most requests. I was not interested in becoming a professional HOA activist. I just wanted to live my life in peace. That said, I did accept an invitation to speak at a local homeowner advocacy group meeting. About 40 people attended, all with horror stories about HOA overreach. Some were worse than mine. One woman had been fined $5,000 for painting her front door red, even though red was listed as an approved color in the covenant documents. Another man had been cited for parking his work van in his driveway, despite a provision allowing commercial vehicles under a certain size. The common thread in all these stories was abuse of authority and homeowners who were too intimidated or too busy to fight back. My message to them was simple: fight back, but do it smart. Use the system. Document everything. File complaints. Get lawyers if necessary. The people running HOAs often count on homeowners being passive. When homeowners push back with facts and persistence, the abusers usually back down or get removed. Life in Meadowbrook Heights settled into a comfortable routine. My furnace worked properly. My space heater sat in the garage, ready if needed but mostly unused. I finished restoring my vintage motorcycle and took it on several trips through the Colorado mountains. Work was busy, my social life was decent, and I had no major complaints. Patricia Wu proved to be an excellent HOA president. She actually listened to homeowners, sought input before making decisions, and treated the position as a service role rather than a power position. Under her leadership, the community came together for neighborhood barbecues, holiday celebrations, and volunteer projects. It was what an HOA should be: a group of neighbors working together for mutual benefit. The space heater incident became a sort of legend in the neighborhood. New residents would hear the story and shake their heads in disbelief. Long-time residents would recount it with the embellishment that comes from repeated telling. I became known as the guy who stood up to the HOA, which was not exactly the reputation I wanted, but I made peace with it. The most satisfying outcome was the ripple effect beyond Meadowbrook Heights. Other HOAs in the area reviewed their governance practices, apparently not wanting to end up in court like Brenda. Several implemented new transparency measures and resident protection policies. A few HOA presidents resigned rather than adapt to new expectations of accountability. The state legislature even considered a bill to increase oversight of HOAs and establish clearer protections for homeowners. The bill did not pass in its first session, but the fact that it was introduced at all showed that the conversation had changed. HOAs were not untouchable fiefdoms. They were subject to the same laws and standards as any other organization. My attorney costs for the criminal case were minimal since the prosecution was handled by the district attorney's office. I did incur some expenses for documentation and time off work for court appearances. Brenda's restitution covered those costs plus a little extra. which I donated to a local legal aid organization that helped low-income homeowners fight HOA disputes. The class action settlement helped several neighbors recoup money they had paid in bogus fines. Robert got back $400 for various violations over the years, including the supposed fence height violation that turned out to be within code. Another neighbor recovered $600 in parking fines based on rules that never existed. The money mattered less than the principle. People felt vindicated and empowered. As months passed and the case faded from immediate memory, I reflected on what I had learned. The experience taught me that institutions are only as good as the people running them. HOAs serve a legitimate purpose when managed properly. They maintain common areas, enforce reasonable standards, and provide a framework for community decision-making. But when the wrong person gets power, even a small amount of power over a small community, the results can be toxic. Brenda was not evil. She was a middle-aged woman who found purpose and identity in her HOA role and let it consume her judgment. She convinced herself that strict enforcement equaled good leadership. She ignored the difference between helping the community and controlling the community. When challenged, she doubled down rather than admitting mistakes. It was a cautionary tale about ego, authority, and accountability. I wondered sometimes if things could have been resolved differently. Could I have been more diplomatic in my initial response? Could I have avoided involving the police? Maybe, but I do not think so. Brenda had established a pattern of behavior over years. My situation was not unique. It was just the one that finally resulted in consequences. The judge's phrase during sentencing stuck with me. People in positions of authority need to be held accountable. That applied far beyond HOAs. It applied to politicians, corporate executives, law enforcement, educators, and anyone else with power over others. Accountability was not about punishment for its own sake. It was about maintaining trust and ensuring that systems functioned fairly. My space heater, the innocent object at the center of this entire saga, continued to serve me well. I used it occasionally when temperatures dropped or when I wanted to work in the garage without heating the entire space. Every time I plugged it in and felt the warm air flow, I remembered the absurdity of everything that had happened. A $400 appliance had brought down an HOA president, resulted in a criminal conviction, triggered a class action lawsuit, and changed governance practices across multiple communities. There was something darkly funny about that. If Brenda had simply left the heater alone, if she had focused on real violations instead of manufactured ones, if she had treated homeowners with respect instead of suspicion, she would probably still be HOA president. Her downfall was entirely self-inflicted, triggered by her inability to recognize the limits of her authority. I ran into Patricia Wu at the grocery store one Saturday afternoon, about 14 months after the trial. We chatted in the produce section about mundane neighborhood matters. She mentioned that the HOA reserve fund was healthy, that several improvement projects were being planned, and that community satisfaction was at an all-time high according to a recent survey. "We owe you a debt of gratitude," Patricia said as we were parting ways. "The changes we made because of your case have transformed how we operate. People actually want to serve on the board now because it is not a toxic environment anymore." "I am glad something good came from it," I replied, "though I could have done without the drama." "Sometimes drama is necessary for change," Patricia said. "You did the right thing even when it was difficult. That matters." Her words stayed with me. Doing the right thing even when it is difficult, that was the core of the entire experience. It would have been easier to pay the bogus fine, get my heater back, and move on. Easier but wrong. Standing up to abuse of authority required effort, time, stress, and risk. But it was necessary. The legal system worked the way it was supposed to. Police investigated. Prosecutors charged. A jury heard evidence and rendered a verdict. A judge imposed a fair sentence. The process was not perfect, but it functioned. That gave me faith in the system despite its flaws. As I write this, nearly 2 years after the space heater incident, life in Meadowbrook Heights is peaceful. The HOA operates efficiently and fairly. Neighbors cooperate rather than living in fear. Property values have increased modestly, driven by the desirability of living in a well-managed community without authoritarian enforcement. Brenda, as far as I know, is living quietly in Wyoming. She completed her probation and community service without incident. Whether she learned lasting lessons from the experience, I cannot say. I hope she did. Everyone deserves a chance at redemption, even people who make serious mistakes. My space heater sits in my garage, a silent monument to an absurd conflict. Sometimes friends visit, see the heater, and ask about the story. I tell them, though I have refined the telling over many repetitions. I focus on the principle rather than the personalities, on the importance of accountability rather than the drama. The story has taken on a life beyond my personal experience. It circulates on social media, appears in articles about HOA reform, and gets referenced in discussions about community governance. Some details get exaggerated or changed in the retelling, but the core remains accurate. An HOA president stole a homeowner's space heater, got prosecuted, and was convicted of criminal theft. That core truth resonates because it captures something many people experience but few address. The frustration of dealing with petty bureaucrats who abuse small amounts of power. The sense that fighting back is not worth the trouble. The resignation that some battles cannot be won. My case proved that those assumptions are wrong. You can fight back. You can win. But you have to be willing to see it through. Looking back, I do not regret how I handled the situation. I wish it had not been necessary, but given that it was necessary, I am satisfied with the outcome. Justice was served. A harmful pattern of behavior was stopped. Reforms were implemented that helped many people. And I got my space heater back. Sometimes on cold winter evenings, I sit in my home office with the space heater running beside my desk, working on software projects or reading news or just relaxing. The warm air is comfortable and reassuring. But more than that, the heater represents something larger. It represents the idea that ordinary people can stand up to abuse of authority and win. That the legal system, for all its flaws, can deliver justice. That communities function better when everyone, especially leaders, is held accountable. These are important principles worth fighting for, even over something as mundane as a space heater. Because it was never really about the heater. It was about respect, fairness, and the rule of law. Those things matter in ways both large and small, in courtrooms and neighborhoods, in constitutions and HOA covenants. My experience changed me in subtle ways. I am more willing to speak up when I see injustice, more confident in challenging authority when that authority is wrong, more aware of the importance of documentation and process. These are useful lessons, applicable far beyond HOA disputes. The space heater continues to work perfectly, reliable and efficient, doing exactly what it was designed to do without complaint or drama. If only more people and institutions function the same way. But since they often do not, since people abuse power and institutions fail, it remains important for ordinary citizens to pay attention, speak up, and hold the line. That is what I did, over a space heater in a suburban neighborhood in Colorado. It was not glamorous or particularly heroic, but it mattered. To me and to my neighbors, and perhaps to people I will never meet who heard the story and felt inspired to stand up to similar abuses in their own communities. The heater sits in my garage, keeping my motorcycle company, ready to provide warmth when needed. And I live my life, working and riding and participating in a well-functioning HOA that learned hard lessons about governance and accountability. The story is over, but its effects continue, rippling outward in ways both visible and invisible. A reminder that small actions can have significant consequences when they touch on fundamental principles. That is my story about the space heater, the HOA president, the theft charge, and everything that followed. It is a story about a specific incident, but also about something larger: the ongoing struggle to maintain fairness and accountability in communities and institutions. That struggle never ends, but sometimes in small ways in unlikely places, over absurd disputes about space heaters, justice prevails. And that gives me hope for the future.